Welcome to today's webinar. My name is Alice Hogue and I'll be your instructor. Today we're looking at real property law. Real property law is something that you need to understand if you're going to be in the oil and gas industry because it's critical whether property is designated real property or personal property. And in this presentation, my goal is just to show you the different types of property and how property is acquired. There's going to be some surprises in there. And then I'm going to give you a little bit of a history lesson. So let's look at the agenda. We're going to go over general concepts of real property law, why we need to understand real property law to do the work that we're doing. And then we're going to look at how real property is classified, or how property in general is classified. Then we're going to talk about how the property is transferred. And we're going to talk about the different types of ownership. You're going to hear these terms bandied about. And I just want you to be familiar with the difference between a life tenant, a remainderman, a joint tenant, and tenants in common, that kind of thing. So I want to make you familiar with the different types of ownership. And that's when we get into a little history lesson. And then we're going to wrap up with a conclusion, and I'll take any questions that you have. So let's begin with general classification or concepts of real property law. Property law can be divided, and by the way, this is on the state bar exam of every state in the United States. This is a 1-hour course. This is a semester-long course in law school that I'm condensing into a 1-hour presentation. So for those of you that are attorneys or have a legal background, if I leave something out, it's because of the time constraints. So property can be divided into personal property and real property. Real property, if you think about real estate, is all interests, benefits, and rights inherent in the ownership of physical property. So let me break that down for you. When we talk about real property, if you think about real estate, initially this designation was to set up to distinguish between the land and the chattels, or the livestock on the land. So one was called real property, like real estate, and the other was called personal property. Now, in Louisiana, we refer to this as real property as immovable property, that is property that cannot be moved, and personal property is movable property. So in Louisiana, real estate, for example, is considered immovable property. Personal property or movable property would be things like a watch, a car, a jewelry, cash. That is all movable property or personal property, things that you can carry with you. So the distinction is, and I guess personal property is a really good way to think about that, is things that you can take with you. The real property, though, is the raw land, and that includes the surface and everything below the surface. And when we're talking about real property and immovable property, in Louisiana, there was a Supreme Court case that where this family bought this home on St. Charles Avenue in New Orleans, Louisiana. Has everybody heard of St. Charles Avenue in New Orleans, Louisiana? St. Charles Avenue is where very wealthy people live. They've got mansions on there that are just stunning. It's also where the trolley car runs in New Orleans. And everybody that lives in New Orleans wants to live on St. Charles Avenue. That's kind of like the Park Avenue of New Orleans. And if you're familiar with The Real World, that MTV program, a couple of episodes of that was in New Orleans on St. Charles Avenue. They lived in one of those gorgeous mansions. So what happened was this couple lived there, and they put this beautiful, very expensive chandelier in the foyer. And when it came time to move, they wanted to take that chandelier with them, arguing that it was movable property. That is property that you can take with you. And it went all the way up to the Louisiana Supreme Court, and the Louisiana Supreme Court said that chandelier is considered real property. It is an immovable because it is affixed to the land. So even though you can physically unscrew that chandelier and take it with you, because at one point it was affixed to the land, affixed to the property, it becomes real property. And that's important for us in the oil and gas industry because that is why oil and gas is considered real property, and the real property laws apply. Because even though you can physically drill into the ground and truck those oil away or put that gas into a gas line, you can actually move it, but because it's a part of the land, it is considered immovable property. So that's why leases, for example, a lease of property is considered real property. Okay, so what's the impact of that? The impact is that if it's classified under the law as real property, then it has to be recorded. It's got to be recorded in the county records in order to be binding against third parties. So if you want to make your claim solid on the property that you're leasing, you're going to record that in the county records. And we'll give you a little bit of a history about recordation in a minute. But that's what lets the world know that you are the owner of that lease. If it's personal property, if you sell a watch on eBay or anything on eBay, a ring, that does not need to be recorded anywhere to be binding against third parties. So when we're talking about real property, it's got to be recorded. Now, let me make it clear that the recording is not what makes it a valid contract. What makes it a valid contract is, and we'll talk about this when we get to contract law, what makes it a valid contract is that it states consideration. So, for example, if I approach Caroline, one of our fellow students, and I offer to lease her land for a bonus of $3,000 an acre and a 1/4 royalty, and Caroline leases to me. She leases to me, okay, and she signs that oil and gas lease. And then another person comes along. Let's pick on Karina here. Karina comes along, and she says, hey, Caroline, if you lease from me, I will give you a $5,000 bonus and a 1/4 royalty. So she leases from Karina and from me. If Karina records that lease first, Karina is the owner of the oil and gas lease. Now, I still have a cause of action against Caroline because Caroline breached her contract with me. But whatever the damages are that I'm going to get as a result of breach of contract from Caroline will pale in comparison to the millions of dollars that Karina's going to make because she is the owner of the lease. So does everybody see it's not recordation that makes the lease binding? It's recordation that makes the lease, puts everyone on notice of who the actual owner is of the property. So that's why it's so important that we distinguish property between real property and personal property. Now, real property, as I said, includes the all-important mineral rights. But there's another further classification of real property and personal property, and that is that property can be either tangible or what we call in Texas corporeal. That means you can touch it, you can feel it, you can see it, you can understand it with your senses. In Louisiana, we call this tangible property. Oh no, in Louisiana, we call it corporeal and incorporeal. In Texas, we call it tangible. Tangible means you can touch it, you can feel it, you can see it with your senses. Incorporeal means literally corpus, from corpus, to have a body. So incorporeal is no body. That means it's something that you have to understand with your mind. So for example, if we're talking about a share of stocks, you don't own a brick in the building if you own a share of the company. You have an understanding that you have a percentage of interest ownership that you have to understand with your mind. There's nothing physical for you to see, for you to feel, for you to touch. You can say, well, what about the stock certificate? Well, that is not your owner. That represents your ownership. That proves your ownership. But that doesn't exactly show your ownership. Another example is an oil and gas lease. An oil and gas lease, you can go out to the property and say, well, where's the lease? And you just show grass. Well, this is the grass. Where's the actual lease? Well, you have to understand with your mind, it's a right that the oil and gas company has to drill on the property. You're not going to see anything on the actual grass or on the actual land. So then you might say, well, what about the lease itself, the lease agreement? Isn't that tangible property or is it intangible property? Well, it's tangible. It represents the right that you have to drill on that property, but it's not, you can't drill on that lease. It's a piece of paper. So that's the difference between corporeal and incorporeal, tangible and intangible. So I just want you to understand that. Other examples are an easement. Again, something you can go out to the property and say, well, here's the easement, but there's nothing really physically for you to say. And any rights to intellectual property. Land is considered corporeal or tangible property. Now, the distinction here is if you're selling a corporeal or a tangible property, you're going to use a deed, some kind of a deed of conveyance. Okay? If you're selling an incorporeal or intangible property, like a lease, you are going to use an assignment of lease. Maybe you're selling an override. You're going to use an assignment and not a deed. Okay, so that's why it's important to distinguish between whether we're talking about the land or we're talking about something intangible that you can't see or feel or touch that you have to understand with your mind, like a lease. Okay, so that is the second classification. Now, let's go into real property law. Now, a long time ago in England, there was a statute passed. It's called the Statute of Frauds. And it originated in England in 1677. And it was designed to put an end to the numerous frauds that were being perpetrated against the court. You see, a long time ago, back in the 1600s or the Middle Ages, the way you would transfer property is you would take something from that property, a leaf, a branch, or some part of that property, and you would then have a formal ceremony where owner A would take the leaf and would formally pass it over, physically pass the leaf over to owner B, and owner B then became the owner of the property. So what happened then was that courts were flooded with people who had a leaf or a branch or a twig, and they would wave that branch or twig and they would say, I'm the owner of the property. And the other party would say, no, I'm the owner of the property. I'm the owner. And there was really no way for the court to say who was the actual owner of the property unless they were physically at this ceremony. So what they did was the courts came up with a rule that said, look, if we're dealing with contract in real property, that is the sale of real estate, it's got to be in writing to be binding. It's got to be in writing. And it's got to be signed by the transferor, by owner A, at least has to sign it. Now, if owner B wants to sign it, I've got no problem with that. But at a minimum, owner A needs to sign that needs to sign that document. All right, so there's no oral contracts for the sale of a property or for the lease of a property. Any contract, whether it's a sale or a lease, must be in writing and signed by the transferor. So that's the Statute of Frauds, an old English law that we still have today that says if it's real property, it's got to be in writing. But then what happened was courts became clogged with people holding their writing, their piece of paper that said, I have the piece of paper, Your Honor. I'm the owner of the property. And the other party would say, no, I'm the owner. I have the piece of paper, Your Honor. So the court said enough. We've got to institute a procedure so that we know who the actual owner of the property is, not just who owns the piece of paper. So they implemented a law that said, in order to be binding against third parties, a conveyance of real property must be recorded in the county records. So it's got to be recorded in the county records. Whoever then records that lease first is going to be the owner of that lease. Now we'll talk about recording. All you're doing is you're going to the county courthouse and you're presenting them with this document, and they charge I think it varies from county to county, state to state, but it's something like $15 for the first page and $2 for every page after that. And they will actually stamp that document and put a book and page number on it or some kind of folio number. and you bring two originals. One you leave with the court, and the other one you keep to yourself, but they stamp both of them so you know what the book and page is. So that's all there is to recording. You could mail that in if you wanted to. A lot of people will just mail that in, and that's perfectly fine. As long as it gets recorded in the county record, you have fixed your claim. You've settled your claim. So that's what recordation is. That's how simple it is. So anytime you're dealing with something with real property, it's got to be recorded in order to make it binding. Okay, let's see. All right, now let's look at how property is transferred. The most usual way that property is transferred is that there's some kind of consensual or voluntary transaction. I sell my property to you, or I gift my property to you. I might leave it to you in a will. That's where I am volunteering. I, as the owner of the property, am voluntarily granting it to you. Or I might put it in a trust and establish you as a beneficiary. And that way, then you would get that property. That is a voluntary, consensual transfer on my part. But there's also involuntary or non-consensual methods of transferring property. One is someone who dies intestate. Someone who dies intestate means they died without a will, without a valid will. And it comes from the Latin to testify. So if you have a will, you're testifying, this is how I want my property transferred. So if we put the N in front of it, it means no testifying. So if you die intestate, you are said to have died without testifying about who you want to get your property. And what happens in those cases is every state has laws called descent and distribution laws. Descent and distribution laws. And what it says is if one of our residents dies without a valid will, their property is going to pass according to state law. And in every state in the union, it's based on who the next of kin is, the next of kin. But now different states define that differently, as you can imagine. And when we talk about probate laws, I think that's in chapter 3 when we talk about probate laws, or module 3. We're going to walk you through what the different state laws are and how these laws are carried out. But all you need to know for today is that when someone dies without a will, the state is going to say how that property interest is going to pass. It's going to be to their next of kin, and then if the next of kin is deceased, it's going to go to the next of kin after that, and all the way down until if there's no one left, guess who gets it? The state gets it. So that is all specified in these descent and distribution statutes. Another involuntary conveyance is a bankruptcy. So someone that files for bankruptcy is giving the court permission, basically, or the authority to transfer their property to satisfy their debts. Another example of involuntary transfer is a court order. In a court order, let's say someone sues you and the judgment says that you are going to relinquish your property. That's not something you did voluntarily. So that's involuntary. And the court then is deciding how your property is want to be distributed. Today we're going to focus on voluntary conveyance of property as far as gifts and deeds. But there's also an involuntary that we're going to look at, and that is adverse possession. So we're going to look at gifts, we're going to look at adverse possession, and we're going to look at deeds. Now, when I was in law school, I had so much trouble with this concept. And when we get to it, I think you'll understand why. But let's first look at acquisition of property by gift. So that's if someone voluntarily gives you property and you don't have to pay any consideration. That means you pay nothing. They just give this to you out of the goodness of their heart. And there's two kinds. It could be inter vivos, which means during the life of the people. Inter is during, vivos is life. These are all legal terms, so I just want you to be familiar with how we're getting these terms. It can be inter vivos, meaning during the lifetime. So I could give to you now some property that my family owns in St. Landry Parish, Louisiana. Or when I die, I could leave a will and pass that property accordingly. So there is such a thing as a gift. Now, I will tell you, I will admit to you that one of my vices is that I watch these judge shows, these Judge Judy shows, Judge Marilyn William. I know it's trash, but I enjoy it for the legal side of it. Right. So a lot of times this is what the case is about. Someone owes you money. Well, no, Your Honor, it was a gift. Well, no, Your Honor, it wasn't a gift. It was a loan. So this is what it turns on. And so I just want you to be aware that in order for it to be a gift, it has to be delivered and accepted accepted by the grantee. And the grantor has to intended to have given it as a gift. So that's where a lot of these court cases are. Okay. All right. Here's adverse possession. Had a great deal of trouble with adverse possession in law school. And what it says is basically it's a way that you can acquire title to real property if you stay on that property for a statutory period. Usually it's like, well, it varies. It could be 10 years. It could be 30 years, depending on whether or not you're considered in good faith. So it's also known as squatter's rights. So if someone sits on your property for 30 years and you don't do anything or say anything, or it could be 10 years, whatever your state statute says, 10 years, in that case, they become the owner of the property. By possessing it adversely against whoever the current owner is, they become the owner of the property. All right, it's also known as squatter's rights. Now, that sounds pretty unfair, right? And that's what I thought in law school. You mean someone can just sit on your property and after a while they will actually own it? And it's not that simple. I mean, they have to prove up certain facts. And one of them is that the possession has to be, and then note that this spells the acronym HELEVA. It's got to be hostile. That means you've got to be willing to defend it. You've got to say, hey, I've got a gun, get off of my property. Not necessarily a gun, but it's got to be, you've got to be ready to defend it. It's got to be exclusive. So you're the only one on that property. If there's a bunch of different people on there, then it's not going to work. It's got to be lasting. That means you've got to be there the whole 30 years. Now, that doesn't mean that you can't go to the store or you can't leave the place, but it does mean that if you go somewhere for 2 years and then come back, you're going to have to start the whole statutory period over again. It's got to be uninterrupted. So if the actual owner approaches you and says, hey, get off of this property, this is my property, you have just interrupted the 30 years or the 10 years or whatever the statutory period is. That means the 30 years has to start all over. So if you're worried about someone adversely possessing your property, all you need to do is tell them to get out. You might send a note, you might send a certified letter to them, some kind of proof to them that, hey, I object. You are not supposed to be on this property. And then it's got to be visible. So they can't just be hidden, deep in the woods where no one can see them. They've got to treat that property as if they own that property. So, for example, they've got to build a house on it. They've got to put fences on it. They've got to be showing to the world, basically, I am the owner of this property. So anyone that is an actual owner of the property is going to treat the property a certain way. That's how these people need to behave if they want to acquire this property adversely. And it's got to be actual. Just paying the taxes is not going to be enough. It's got to be, you've actually got to be physically on the property, paying the property. And in some states, it's got to be under a claim of title. In other words, you have to believe that you are the owner of that property. Now, why would the states, here's the concept I had so much trouble with, why would the states have the ability for people to own property adversely? What is the benefit to the state to having an adverse possession laws? Well, remember, the goal of the state is for every person to be self-sufficient, every person to be independent, to be able to support themselves so they don't end up on the state welfare rolls of the state so that the state has to support them. So the state will say, look, if someone owns a large, and this is really common like in Montana or Wyoming where they have these huge, ranches. Let's say someone comes over here and adversely possesses this part, okay? That person may drill on it. They might plant crops on it. They might have cattle on there. That is going to give that person the opportunity to support themselves. And so the state says we would rather have land be used than unused. So if you meet these qualifications, then you are going to be able to actually acquire property without going through the process of having the current owner transfer it to you. That's called adverse possession. I don't know how many of you see that when you're doing land title. I have seen it before, but not that often, I must say. Now, this also works if you have a neighbor, and let's say that a hurricane or something knocks down the fence between your property, okay? And then your neighbor comes in and he drills another fence. Let's see, here was the original fence, and here's your property. And he builds another fence that cuts like 1 foot into your property. All right. If you do nothing or say nothing or just let it slide, and he continues to hold that property for 30 years, after 30 years, your neighbor now owns this little stretch of property in addition to all of his other property. Okay. So it's real. It can actually happen. But as long as you interrupt it, as long as you say, hey, get off the property, send a certified letter so that you can prove that you objected to this, you're going to be fine. But if you do nothing or say nothing, this property can be adversely acquired against your will. All right. So that is adverse possession. Okay, I'm getting some questions here. Let me see. Yes, great questions. Okay, it does matter. The question is, does it matter what county that transfers of real property are recorded? And the answer is yes. It's got to be recorded in the county where the property is owned. So if you live in Florida and you have land in Oklahoma and you transfer your interest in land in Oklahoma, or you lease it, and you record that document in Florida, that's going to have no impact. It's got to be recorded in the county where the property is owned. Tim, we're going to talk about how does a testamentary gift differ from a life estate in a second. You'll see. I'll give you a really good example of that. Okay, good questions. All right, now, by far the most common way of acquisition of property is by a good old-fashioned deed. And a deed is defined as a legal instrument that transfers ownership of real estate. That's by far the most common kind. So then let's look at what a deed is. A deed contains the names of the old owner and the new owner. It contains words of grant. That means it says, I grant, convey to you in this amount. It's got to have a proper legal description, and it's got to be signed. So those are the key elements of a deed. It's got to be signed by the transferor. Okay. So now, can we have a verbal agreement to convey property? Raise your hand if you think the answer is yes. Can we verbally agree to transfer property? And perfect. I see no hands up. That is correct. It has to be in writing. Remember the statute of frauds. So there's no verbal or oral agreement for a sale of property. All right. Now let's look at the different types of ownership of property. You've heard of life estate, you've heard life tenant, you've heard remainderman, joint tenants with right of survivorship, tenants in common. I want you to understand what all those different terms are. And so the different types of ownership are defined as the degree, nature, and extent of an individual's ownership in real property. Whenever we're talking about real property, we're most commonly referred to as the freehold estate. Now, I'll give you a little bit of a history lesson here. Now, I warned you. a long time ago, land belonged to the monarchy. Not only the minerals, but the actual surface belonged to the monarchy. Then in the 1000s, there was a king called King Edward. He was actually a Catholic saint, Edward the Confessor. And I don't know if you know your history, but at that time, France and England were kind of almost synonymous. You know, they different parties owned it at different times. And so William of France was the cousin of Edward, King Edward. And William of France said, when we were kids growing up, King Edward promised me that if something happened to him, that I would become the successor. And the other possible successor was Harold of England. Harold of England was Edward's sister's husband. Harold was Edward's brother-in-law. And so they had a big convention, and the parties that be convened, and Harold ascended to the throne. Harold became the King of England. Well, cousin William didn't like that one bit because he felt like the throne rightfully belonged to him. And so in the Battle of Hastings in 1066, William the Conqueror invaded England and became the king. Now, he wanted to reward his knights in various degrees. I forgot to mention something. When land belonged to the monarchy, the way it worked was that if you were a private business, you could mine the royal mines only if you made a payment to the crown, and that payment was known as a royalty payment. That's just a little trivia for you. Was a royalty payment. That's why we still call them royalty payments to this day. Okay, back to the Battle of Hastings. So William the Conqueror wanted to reward the people in his valiant knights, depending on their bravery. And what he did was, for the first time in history, he gave grants of land as a reward to his knights. So for the first time, the people themselves were able to own the land. Now, he gave them to them, anyone associated with the conquest, in different degrees, all right, depending on how brave they were. So if they were very brave, he would give it to them outright. In other words, he would give them a fee simple. You'll also hear this referred to as a fee simple absolute, okay? That means you are the absolute owner of the property, the surface and the minerals. Surface and the minerals, okay? That means you can do whatever you want to that property. If you own in fee simple or fee simple absolute, you can sell it, you can convey it, you can lease it, you can mortgage it, and when you die, you can pass it on to your heirs. Another type of ownership is, this is fee simple absolute again, and it is the right in law to the use and possession of the land to the exclusion of all others. Think about someone that owns a fiefdom. They are said to own fee simple. So the land is given without limitation to the inheritance of the heirs, and it's unrestricted as to the transfer. You can sell it, convey it, lease it, mortgage it, and it includes the surface and the minerals. So then let's move on to another type of fee simple. Contrast fee simple to a determinable fee. That means you don't own it absolutely. You only own it for a determined period of time. So in fee simple, the person is the absolute owner with all the rights of ownership during the person's lifetime and the right to dispose of it as the person wishes at death. But when we're talking about determinable fee, that is, one is entitled to the use and benefits of the property for life. Okay, but when they die, those rights cease, and that is what is known as a life estate. A life estate. So let's look at what happens in a life estate. Let's say that mom and dad are married. Dad and mom are married, and dad owns separate property over here, some oil property. Okay, it's not community property, so dad owns it himself. All right. When dad dies, he wants mom to get, and let's say they have 3 kids. When dad dies, he wants mom to get the property. But ultimately, he wants his 3 kids to get the property. So rather than run the risk of transferring everything to mom, and then mom gets married again and has kids with that guy, and then all of dad's property passes to this other man's kids. So in order to prevent that, dad says, okay, I'm going to transfer it to you, my dear, during your lifetime. But when you die, that property is going to pass to our 3 kids. So these 3 kids have the ultimate ownership of the property. That means that mom can't convey it, can't sell it, can't mortgage it, but she can use it during her lifetime. In Louisiana, we call this a usufruct. You got to be real careful how you say that word. We call that a usufruct. In Texas, we call it a life tenant. Okay, and it's called this woman is known as the life tenant in our scenario, and she owns a life estate. She owns a life estate. So that's defined as an estate whose duration is limited to the life of the party holding it. She can only own it during her lifetime. The beneficiary, the life tenant, is entitled to the income from the property for his or her lifetime. So in Louisiana, we call it the usufruct, which means she has the right to the use of the fruits. And that's why a lot of times the life tenant is the one who gets the royalty payment, because she's entitled to the profits, or if you want to think of them as the crops from the field. She's entitled to the usufruct, the use of the fruits. But when she dies, the property is going to go to the remainder interest, what we call in Texas the remainderman. Okay. And that's Texas. So Texas, we call it life tenant and remainderman. In Louisiana, we call it usufruct, and instead of remainderman, we call that naked owners. Doesn't that sound like more fun? Okay, and everybody knows the difference between naked and naked, right? This is going to be on the final exam. I'm stealing this from Jeff Foxworthy. Naked is when you don't have any clothes on, and naked is when you don't have any clothes on and you're up to something. So in Louisiana, we call these naked owners, which means they are free of encumbrances. They can do whatever they want once the property passes to them. So life tenant, remainderman in Texas, usufruct, and naked owner in Louisiana. That is what a life estate is. So that's different than passing it to someone in a testament, in a will, because in a will you're usually giving it to them for forever. They are actually going to be the owner of it. But you can convey a life estate in your will as well. You can say, I bequeath this to my wife during her lifetime, and that is considered a valid transfer of property. Now, another way so is everybody clear about life estate? Does anybody have any questions about life estate? I know it's kind of a confusing concept, but if you'll just remember this scenario, dad is trying to make sure that his kids inherit. So he's just giving it to her for her life. Just keep that in mind. Okay, let's move on then to other types of ownership. And this is divided ownership and undivided ownership. You've seen on a lot of deeds, it says so-and-so owns an undivided interest. Undivided interest. That means they own more than one person owns it. If a person owns a divided interest or an individual interest, that means they own 100% of the minerals. So that's just when one person owns it. Now, if it's undivided interest, that means that the parties own as joint tenants, or what we call tenants in common. In this case, 2 owners can, tenants in common, often abbreviated TIC. So here's where 2 owners each own a 50% interest. So if you look at, for example, someone that owns property, and let's say they own it as tenants in common. Okay, let's say there's 3 of them. This person owns 33%. 33 and a third, this is 33 and a third, and this is 33 and a third. Okay. Where is this party's interest? Is it in the northwest quarter, the northeast quarter? What is the property description that this person owns? And the answer is that person owns 33%, 33 and a third percent of the whole. You can't divide it out. You can't say, well, this is this person's property. You can't divide it out. They own literally 33 and a third percent of every molecule in that piece of property. That's why it's called undivided interest, because they all own equally, or whatever their percentage of interest is. They each own their 33 and a third interest. Okay, so that's the difference between divided. If it was divided, this person could own 1/3, this party could own the other third, and this party could own the other third, and they would actually be able to give you a physical description. I had one owner send me a deed one time and said, I want to convey 3 acres to my daughter. Well, ma'am, if it's an undivided interest, there's no way you can convey 3 acres. You can convey a percentage of your entire acreage, but you can't divide it out that way. So I want you to understand the difference between divided interest and undivided interest. So undivided interest is also known as joint tenancy, or as I said, tenants in common. And what it is, it's ownership of real property by 2 or more owners. So you have tenants in common, you have joint tenancy, and you also have something called joint tenancy with right of survivorship. Now I'm looking at this slide and I'm thinking, you know, I think it would be better if we called this tenancy in common. Because joint tenancy, a lot of times people confuse that with this joint tenancy with right of survivorship. And I'll go over what that joint tenancy with right of survivorship is. But I just want you to be aware that that can be confused. It is technically joint tenancy, but it's going to be less complicated if we refer to them as tenants in common. Okay, so you've got tenants in common. Another way to say that is joint tenancy. And joint tenancy with right of survivorship is a different animal, as is tenancy by the entireties. So now let's look at this joint tenancy with right of survivorship. You'll see property frequently owned this way. It's a way to avoid probate, so it's really a good idea to own that way. And the way it works is, well, if you have joint tenancy with right of survivorship, that is saying, let's say that A and B own property. All right, they are joint tenants in this property. And A says to B, if I die, the property is going to automatically pass to you. Not to my heirs, but it's going to automatically pass to you. And B could say the same thing. B said, if I die, all my property is going to pass to you. This is common in a husband and wife situation because they don't want to have to go through a formal probate. So if they own the deed as Mr. and Mrs. A and B, as, and they'll abbreviate it, joint tenancy with right of survivorship. In that case, if A dies, the property passes to B. If B dies, the property passes to A. Now, if they own this property as joint tenants with right of survivorship, and A, before A dies, conveys this property to C. In that case, we have destroyed joint tenancy with right of survivorship. In other words, when B dies, he doesn't have to pass his conveyance to A, or to C rather. He doesn't have to pass his conveyance to C because A sold it to property. She's destroyed joint tenancy with right of survivorship. So if B dies, the property is going to pass to his heirs, and when C dies, the property passes to her heirs. So we just don't want to have a situation where where B has to pass property to someone he doesn't know. So if the property is sold that way, then we're going to pass as tenants in common. or we're going to pass, yeah, then these parties, B and C, then just become tenants in common. Okay, so now let's look at joint tenancy with right of survivorship. The other type is called tenancy by the entireties. This is exactly the same as joint tenancy with right of survivorship, but it's only for a husband and wife. And this is in certain states, they'll refer to it as tenancy by entireties. I can't think right off the top of my head what states do it. I think it's Oklahoma is one of them that does it. But that's the way some states call joint tenancy with right of survivorship tenancy by entirety. And it's the same thing. You can't encumber the property if we own it as joint tenants or joint tenants with right of survivorship. You've got to have mutual permission. So if you're taking a lease from someone and they own as joint tenancy with right of survivorship or as tenancy by entireties, both parties have to sign that oil and gas lease. Both parties must sign the conveyance instruments. Now, if these parties then divorce is just like selling it to a third party. That is going to destroy tenancy by entireties, and they are going to become tenants in common with their undivided interest. Okay, how's everybody doing? Everybody with me? Okay, let's move on to homestead. I just want you to be aware, this is similar to where you have to get permission of both parties. It's your primary residence. And in order to be considered a primary residence, you have to live on your property, and only one residence is going to qualify for the exemption. Those of you in Texas are familiar with this exemption. So any property that's designated as a homestead is going to get their property taxes reduced, or there's an exemption for the homestead. Now, if you're leasing on property that is considered a homestead, it's important that you know that both the husband and the wife must both sign the lease. And just a little bit of history for this. This was developed during the Depression, and it now prevents creditors from seizing someone's home so people are not homeless. Provides shelter for a surviving spouse and requires consent of both spouses to sell or encumber. Now, in most cases, this does not apply to mortgages, mechanics liens, or delinquent property taxes. So, for example, your home can be seized if you don't actually own it. In other words, if the bank owns it. I know y'all have all seen these foreclosures and wonder, well, what about the homestead exemption? If you own your home outright, no one can seize that property from you, even if you file for bankruptcy. And it's a shelter for the surviving spouse, so the surviving spouse will always have a home. But for our purposes, the reason you need to know about it is that it requires consent of both spouses to sell or encumber the property. So if you've got a lease, that lease has got to be signed by both the husband and wife if the property is designated as a homestead. Another type of property ownership that you need to be aware of is that of an easement or a right-of-way. Most of you are familiar with this. You've got a cable easement in your backyard or some kind of an electrical easement. And what it does is it gives one party the right to use the property of another party, the right of use. They can't sell it, convey it, or encumber it like with a mortgage, but they have a right to use it. Unlike a lease, an easement does not give the holder a right of possession of the property, only a right of use. And in Louisiana, we call this a servitude of passage. So easement's another type of ownership that I want you to be aware of. It gives someone the right to use the property, but not to actually sit on it and possess it. Unlike a lease, where you can actually sit on it and drill that well on it. Okay, and that concludes our presentation on real property. So what we did was we walked you through some general concepts of real property, and we talked about how property is classified, either as real property and personal property. And we said oil and gas was considered real property because it was affixed to the land, just like in that Louisiana Supreme Court case, the chandelier became the real property, even though you could physically remove it. And the other property, the chattels, the watch, the car, the washer and dryer, those are all considered personal property. It's further defined as tangible property, or this could be tangible property or intangible property. And if it's tangible property, that means you can touch it, you can feel it. If it's intangible, it's something like a lease. Then we talked about how property is transferred. We talked about gift, we talked about adverse possession, and then we talked about, by far the most common means is a deed, or if it's intangible property, an assignment. And then we talked about the different types of ownership. And what we said was that in the Battle of Hastings, William the Conqueror, Edward's cousin, gave land to people based on their level of bravery. And so he had some land that he gave outright. That was a fee simple, also known as a fee simple absolute, where you own the surface and the minerals. And the other kind was a determinable fee. That means you own it for a certain determinable amount of time. And that is what we call a life estate. Or in Louisiana, a usufruct. Okay, and then we looked at the actual different types of ownership. We talked about an undivided interest. We talked about joint tenancy. We talked about tenants in common. We talked about joint tenancy with right of survivorship. We talked about the life estate. And we talked about tenancy by entireties. Tenancy by entireties, which is the same thing as joint tenancy with right of survivorship, but it's only for husband and wife. And then we looked at another type of ownership, which is easements. And then we looked at the homestead exemption. And that wraps up our presentation on real property law. Are there any questions that anybody has? Let me see if I've gotten any questions. You can either raise your hand and I'll recognize you. Oh my goodness, I've got a long one here. Let me see. If the Southwest Quarter, for example, is owned as an undivided interest owned by 4 mineral owners, okay? Everybody got that situation? Let's say the Southwest Quarter, and we'll go over legal descriptions next week if you're not familiar with this, but let's say that the Southwest Quarter, which is right here, is owned by, is owned as an undivided interest by 4 mineral owners. And one owner sells his south half of the Southwest. Oh my goodness, I just lost my. And one owner sells his south half of the Southwest, which is going to be this property. Let's say he sells that. Doesn't it split the undivided interest now into the north half of the Southwest and the south half of the Southwest? He cannot split it that way because he doesn't own just this. All he can do is convey, let's say you have 4 owners, all he can do is convey his 25% mineral interest. He can't convey the south half of the north half. He can only convey in fractions. Any other questions? Really, the only way you can split an undivided interest is by something called a judicial partition. That means, let's say these family members are feuding, okay? And this person wants to sell his Southwest or the south half of the Southwest Quarter. He's going to have to sue his the other co-tenants, and he's going to say, I'm suing for the right to a judicial partition. I don't want to own a percentage interest with these yo-yos anymore. So they'll sue, and the judge will actually divvy out the property. They'll say, okay, party A, you own this quarter. Party B, you own this quarter. Party C, you own. That's the only way that you can divide out an undivided interest. So this person cannot sell just half of, he can sell half of my 25%. He can sell, half of his 25%, and then he would own 12.5%, and the other party that he sold it to would own 12.5%. But he cannot sell any particular property description in this acreage. Good question. Any other questions? That's why it's undivided, exactly. Okay, any other questions? I don't see hands up. Oh, Laura, do you have a question?
Nope.
Okay, sorry, I saw your hand up. Anybody else with a question? Okay, at this point, I'm going to stop recording, and I look forward to seeing you in the next webinar.